Hello, and thank you for joining us for the SLW Institute webinar, How the UPC Has Changed the Patent Landscape in Europe. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. We will also put a link in the chat to where the presentation slides are posted online. If you would like to ask a question, you can enter the questions using the Q&A feature in the Zoom menu or in the chat. We will address the questions either during the presentation or at the end, time permitting. My name is Adeel Haroon. I'm a principal here at SLW, and I will be your moderator today. Our guest speaker will be Graham Burnett-Hall, a partner at Shoosmiths. He is based in London. Graham is a leading patent litigation practitioner with over 25 years of experience. His cases have spanned all areas of technology, including pharmaceuticals, biotech, medical devices, electronics, and telecommunications. In addition to patent issues, Graham frequently advises on other intellectual property rights, such as designs and trade secrets, and on the strategic use of intellectual property assets to achieve commercial goals. The disputes Graham advises upon are frequently multi-jurisdictional. He has considerable litigation experience in cases involving parallel proceedings running across Europe, including the Unified Patent Court and other jurisdictions worldwide, such as the United States and China. And with that, I'll turn things over to Graham.
Thank you, Adeel, and thank you, first of all, for inviting me to speak today. I'm delighted to be here, and thank you to SLW and everyone who's been involved in setting this up. I'm aware a lot of work's gone into the preparation, so I'm very grateful for that, and thank you again. I'm going to spend the next few minutes talking about the UPC and exactly how it has transformed European patent litigation since it opened its doors a little over 18 months ago. The simple answer is a lot. In fact, on February the 14th, the court published its first annual review covering 2024, the first full year of operation, and it's available on their website. And in fact, we'll see a lot of the slides use information from their website. It's a really good resource if you want to get further information about the UPC and its operations. But looking at their annual report, one comment that that both the Klaus Grabinski, the president of the Court of Appeal, and also the president of the Court of First Instance and the head registrar have written articles for this review. And if I start with Klaus Grabinski, he ends his article by saying, based on what has been achieved at the UPC so far, I am confident that the court will establish itself as a central pillar of the European patent system, providing users of the system with a single place of litigation with effect for large parts of the European market. Well, he says it will establish. My conclusion is it already has. Without doubt, this court is here to stay, and it simply cannot be ignored if anybody is looking at patent litigation, patent disputes, or even developing their patent portfolio and looking at the European market. So with these slides, I'm going to go through the first half dozen or so as quickly as I can. I imagine a lot of the people watching today will already have some idea about the UPC and its structure and setup. So I will go through very quickly just to explain, well, what is it? How is it operating? And then I will focus on some slides really going to the title of the webinar today about what has its impact been. And finally, there are a number of slides which contain various statistics and data, again, all published by the UPC, about its caseload and the nature of the cases. And that will all be there in the slides, which I understand will be available for everybody afterwards. So please, there will no need to try and make notes. It's useful resource. I may not actually talk to every slide. I thought it would be useful information for people to be able to access later on. So let's start with the jurisdiction of the UPC, and I'm looking both at in terms of the rights it has jurisdiction over and also territorial jurisdiction. So at present, it's all the signatory states of the UPC agreement. The agreement goes right back now to 2013 that set up the Unified Patent Court. All those signatory states are European Patent Convention states, but not only that, they are also all EU states. And the way the court has been structured, it is not strictly speaking a European Union institution. That was done quite deliberately, and I'll explain why in a moment. But all the participating countries are EU countries. And there is a question mark. If we look at European patents granted by the European Patent Office, which again is not an EU institution, there's about 40 participating countries. That includes all the EU countries, but also important jurisdictions such as the United Kingdom and Switzerland and Norway and Turkey. And originally, people, or at least some people, were hoping that there could be a unified court, not just for EU countries, but for all EPC states that wanted to participate. And maybe at some point in the future that will come to pass. But at the moment, it is looking like this court is only open to EU members. We'll see. Lots of us here in the United Kingdom would love to see it be available to cover more countries, more EPC states, but it's really a matter of ensuring the primacy of EU law. And the EU Court of Justice, the CJEU, gave an opinion some years ago saying that if participants included non-EU countries, it was concerned that that may not mean that the court would not give proper effect to the primacy of EU law, which within the EU is held sacrosanct. It is really a matter of law and politics. So we will see what happens on that. So right now we're looking at 18 EU countries that are participating, and the court itself will have jurisdiction over European patents in force in those countries as a starting point. And those European patents, now an important part of the whole package that brought the UPC into operation was a separate EU regulation that also allows for unitary patents. So European patents that, when granted by the EPO, will not exist as a bundle of national rights, the classical European patents that we already have and have had since the start of the EPC and the European Patent Office, but also unitary patents. So, as the name implies, a single right, but whose effect covers multiple territories. And these are proving really quite popular. It's particularly useful for anyone wanting a patent covering 4 or more countries, because above that, you will find that having separate national rights, the renewal fees cost more than a unitary patent. Below that, and the majority of European patents are in fact only validated at the moment in 2 or 3 countries. Very often it might be Germany and France and the UK. And if it's just at that level, then in terms of costs, it's often cheaper just to stick with the classical model. But in terms of what I'm calling the classical European patents, the UPC has jurisdiction, but because of transitional provisions in the UPC agreement, it's also the case that national courts can also have jurisdiction over classical European patents, and indeed it's possible for proprietors to opt out, and then only the national courts have jurisdiction. So when the court came into operation, there are many thousands of European patents where the proprietors opted them out. They were nervous about whether the court would turn out to be reliable, or if, for example, it's protecting a core product, say take a blockbuster pharmaceutical, You may not want it to be ever to be possible for it to be revoked across multiple jurisdictions. It would be much better as a matter of patent strategy and defensive strategy to ensure that it had to be knocked out country by country. So that's European patents in the classical form. When it comes to unitary European patents, there's no opt-out. The only court that has jurisdiction over unitary European patents is the UPC. Ultimately, the transitional provisions are going to end, but it's going to be many years from now. And at that point, the UPC will have exclusive jurisdiction over all European patents in force in participating member states. There is, in addition, the possibility of what we call long-arm jurisdiction. It's already been one decision quite recently, Fujifilm, where the UPC court has affirmed that it would have jurisdiction over a European patent validated in the United Kingdom, where the proprietor was a German company domiciled in Germany and was the defendant in UPC proceedings. In principle, a question of infringement of the European patent's UK validation could also be determined by the UPC. So there will be an element of cross-border, though that's likely to be rare. So if we look now, here's a picture just summarizing the countries that are participating in the system. The point to note here is that not every country that has signed the UPC agreement has ratified it. And in terms of where the court can currently have jurisdiction or where divisions of the court can be located, those have to be countries that have ratified. So we have 18 countries that have ratified. Of the ones that have signed the agreement but not yet ratified, the most important jurisdictions, I would say, are Ireland and the Czech Republic and Slovakia. The Ireland is of particular interest to UK litigators because for the UK, for lawyers to continue to be actively participating in this court as representatives, the ability to represent clients in this court, the easiest way is for us to be practicing and have practicing certificates for the Republic of Ireland. So there are quite a few, you will find, UK-based litigators who have also based themselves in the Republic for at least part of their time so that they can continue representing clients directly in this court. In terms of the structure, it's two levels of court. There's a court of first instance and a court of appeal. The court of first instance has lots of divisions. Every country that's participating in this court can have a local division, or two or more countries can club together and set up a regional division to cover their territories. And you can have more than one local division. Germany, in fact, has 4 local divisions, and every other country, though, has only gone for a single local division, or is participating in a single regional division. And in addition, there is also what's known as the Central Division. And the Central Division has 3 branches. They're located in Paris and Munich and Milan. One of the branches was going to be in London, but a consequence of the UK leaving the EU, Brexit, as we all call it, is that the UK withdrew from the UPC agreement, and it therefore gave up its part of the Central Division, and it's never established a local division. Now, what matters about these divisions? Well, there are rules about where claims have to be begun. At a very simplified level, if you're a patentee bringing an infringement case, you need to bring that claim in a local or regional division, either where a defendant is domiciled or where an infringement is taking place. Now, straight away, what that means is if there is a product that is available throughout Europe, you have a choice of bringing your claim in any local or regional division because there will be an infringing act. So forum shopping is a huge aspect of the impact of this court, and I'll be talking about that in quite a lot of detail later. The central division principally is where you will bring your claim if you're applying to revoke a patent. So extremely important in the medtech sector and in the pharma sector, where it is expected that you will clear the way before launch. And if you don't, you can expect to be on the receiving end of a preliminary injunction. And the central division is the primary forum or the primary place from which you would bring a patent revocation claim. It's also where a declaration for non-infringement would be started, which is often done in conjunction with a revocation claim by parties seeking to clear the way. That said, there have not been very many of those, to my knowledge, since the court started operation. Now, in the Court of Appeal, it's much simpler. There is a single Court of Appeal. It's based in Luxembourg. And that's really important because it can hear appeals both on the merits of substantive decisions, the infringement or revocation of patents. It can also hear appeals on procedural matters. And it is by having this single Court of Appeal sitting in Luxembourg that we're going to see a consistent and coherent body of case law being established by the UPC and avoiding conflicting decisions. You may well, at first instance, get decisions that appear at odds with each other, depending on which division or even which panel within a division reached or gave the judgment. But over time, these are going to be appealed, and we're going to get a coherent case law that will guide the lower divisions, meaning that the court should be highly predictable. You will see there's two boxes on the sides. The one on the left, Patent Mediation and Arbitration Center, that isn't up and running yet. It will be up and running soon, we're all led to believe, and it remains to be seen just how much impact it will have. It's possible, once it's running properly, the divisions will have the authority to refer a case to that center for mediation or arbitration, and whether the divisions actually will exercise that right or not remains to be seen. And whether the parties will want to. Again, most likely it will depend on how useful it turns out to be, how good the people are. What's amazing is people think disputes that can never be mediated, people think it'll never work. Somehow, so often, when they're actually in the room together, they come out with a settlement and save themselves a small fortune in legal fees. So I would never say just don't even give it a go. I would always think very seriously about whether mediation might be a good way of resolving a dispute. On the right-hand side, we have a box marked CJEU, the Court of Justice of the European Union. And this is important about upholding the primacy of EU law, which was essential for the countries to be able to set up a mutual court in the first place. And any questions of EU law will need to be referred to the CJEU unless they're completely clear already. Now, this has not yet happened, and the court was deliberately structured so that the Court of Appeal is the final court for substantive patent law issues. There is no EU regulation saying the scope of protection given by a patent in EU countries will be as followed, because if there had been, just as with EU trademarks or EU designs, you would have had a succession of appeals because it would have been the CJEU that would have been the final court to interpret what that meant. And the truth is that, the CJEU judges are not IP specialists or certainly not patent specialists, and everyone setting it up wanted to try and avoid the delays and the uncertainties that would be caused by lots of appeals going to the CJEU. There will still be appeals on EU laws, such as there is the IP Enforcement Directive, which is to do with remedies. That could well result in referrals. Most importantly, supplementary protection certificates, the EU's equivalent to patent term extensions. Those are going to inevitably involve referrals because it is an EU regulation that established supplementary protection certificates. But so far, not a single referral. Now, I could see that we have one question coming in about language that will be coming up on one of the future slides. Yeah. Now, in terms of the central division, as I mentioned, there's 3 branches. In terms of which branch you have to go to, it is established very much by the primary classification of the patent in suit. And this is following the WIPO International Patent Classification rules. And you will see that very broadly speaking, there are the main classes A to H, and the division now, as you can see, that London is crossed out deliberately, and you will see some wording is in italics. This is changes that happened following the UK's departure from the UPC system. What it means, in short, is that most medical devices are classified as a patent classification in Class A, and therefore invalidity claims concerning a lot of medical devices are going to be heard in Milan. In terms of the Paris, there's lots of classes, but the most important are G and H at the bottom. This is what covers telecommunications patents. So a lot of validity cases involving telecommunications will go to Paris. Finally, in terms of Munich, Class C, which says chemistry, but in practice, this covers pharmaceuticals and biotechnology. And those claims, those revocation claims, will now be going to the Munich branch of the Central Division. That said, only if the patent does not, or the case does not involve an SPC. If it involves a supplementary protection certificate, it will be Paris that hears it. So these are all things we can cover. The important thing, though, is to remember that this is an international court. And when we look at the judging panels, which I'll come to in just a moment, we will see that just because you're in Paris, it does not mean you're going to be in front of a panel of French judges, for example. So in terms of who's allowed to actually represent clients in this court,
Graham, could I ask a
yeah,
question?
sure.
Something
Yeah.
that I think people might have a question about. Could you go back and just explain what supplementary protection certificates are and why like Paris seems to have exclusive jurisdiction on them?
Yes, well, so they're Europe's equivalent to patent term extensions. So they're relevant primarily for pharmaceuticals and veterinary products and crop protection products. And it's to do with the length of time it takes to get marketing authorization for these products. And it's recognized that because it takes so long and the costs involved in obtaining marketing authorization are so high, that it's reasonable to reward patent proprietors with, in effect, up to 5 years additional term of protection for products that have finally been approved onto the approved for receive marketing authorization. And it's up to 5 years. There's a formula which is applied to calculate what length of term a supplementary protection certificate should have, but it will never be more than 5 years on top of the underlying patent.
Okay.
Yeah, and then why Paris? That comes down to political, just political negotiation. So this wasn't the situation before. The original negotiation involved London and Paris and Munich battling it out for who was going to get which share of this work. And London walked away with, for people like me who do an awful lot of medical device and life sciences work, considered to be really quite a glittering prize in that Class A, which covers a lot of medical devices, and Class C, which covers pharmaceuticals, were both going to London with or without SPCs. So London came away, had a very good deal, but sadly that is all gone. So we and following that, if I don't want to get too controversial, but yes, Milan put itself forward as saying, well, we'd be happy to step in now that London can't host a branch of the Central Division. And it would appear that France and Germany said, well, in principle, yes, but we want to have a little discussion as to who's going to get what. And they carved it up again. So that's what's happened. Okay. So representation in this court, the point I'm going to make, because when I start looking at the impact, the key thing here is it's both litigation lawyers who can be representatives and also European patent attorneys. And a fundamental part of this court and the way litigation is being run and will be run is that you need a team with both a litigator and a patent attorney. And that is absolutely crucial. And when we look at the impact, how you run a case, we always need to be thinking in that way. This is something that's actually very, part and parcel of patent litigation in most continental European jurisdictions. They're very used to the idea of having patent attorneys on the team. In common law jurisdictions such as England and Wales and the Republic of Ireland, that isn't so much the standard default. We tend to rely much more on party-appointed experts, and then we have a litigation team. The experts will give evidence and be cross-examined, and that's how the court educates itself in technology. In the UPC, what we're seeing is experts having a much smaller role, and the patent attorneys, the parties make their technical submissions, and then when on the next slide we'll be seeing about the judging panels. Those as well will have people who are technically qualified. So that has a real impact on how you prepare your case. So let's look at the panels of the UPC. At first instance, we have local and regional divisions and the central division. And the first thing is all the panels have a multinational composition. There will not in any division be more than 2 judges of the same nationality. And if there's whether there's 2 of the same or not depends on how many cases that country has traditionally heard. So in Germany, which has a lot of patent litigation, if you bring a case before a German local division, 2 of the 3 judges will be German, 1 will not be German. In other divisions, which traditionally had a smaller number of cases, there will be a single judge from the country hosting that division, and the other 2 will come from other countries. But the main point to note is it's multinational. And what this also means, a key theme I'm going to be saying again and again, is English, English, English. We're going to see that the language that the judges are working in most cases, is English. And it's completely understandable when we realize that there's a multinational composition. Now, that's in the local and regional divisions, which is where you will normally be bringing infringement cases. These are all, the starting point is 3 legally qualified judges. If the defendant brings a counterclaim for invalidity, then the local and regional division, first of all, it has an option. Will it hear that counterclaim, or will it send the counterclaim off to the central division for determination? In almost every case, they say, we're going to hear it. And if they do, a technical judge is appointed to the panel, so there will then be 4 judges. With revocation claims that are normally just brought straight in the central division, the panel's composition will start with a technically qualified judge, forming one of the 3. So 1 technically qualified, 2 legally qualified judges. And at the Court of Appeal, we see there's 5 judges. It's a multinational composition. That's 3 legally qualified judges that will be a multinational composition, and then 2 technically qualified judges are appointed. Basically, there is a pool of technically qualified judges, and they are appointed to each case, either at first instance or at the Court of Appeal. And so this, again, in terms of the impact, how you're going to prepare a case is always with this understanding that on this judging panel, we have very much lawyers, if you like, people steeped in legal jurisprudence, understanding, specialists in patent law, but also in legal law as jurisprudence in general. And there will, in addition, though, always be, if validity is an issue, a technical judge. And the technical judge is not a second-tier judge. They are a judge with as much authority when it comes to making decisions as a legally qualified judge. And so when it comes to the deliberations, they have equal say. If you're saying should there be a preliminary injunction, think about these sort of applications, not just the final decisions on validity and infringement. They are all judges and they have an equal say. However, inevitably, when it actually comes to technical issues, it is going to be the role of a technically qualified judge to ensure that the panel as a whole understands the technology before it. And so we will always be preparing cases and thinking of our technical submissions with the technical judge in mind. And you've got to make sure that obviously you want the whole panel to have understood your case, but at the very least, you've got to make sure those technical judges are completely on board with the technical points that you're making, because they are bound to be highly influential when those points come to be considered before judgment's issued. So
Graham,
proceed. Yeah,
got a
Adeel.
question for you.
Yeah.
So what impact do you think having a technical judge on a panel would make in terms of presenting evidence? For example, the use of expert testimony. Do you think it would increase the use of expert testimony or decrease the use?
Well, it's I would say decrease is the experience we have so far, and that's very, very, very timely. And if we look at the bullet points on this slide, the experience so far is that there's a procedure, and you'll be pleased to know I'm not going to go through the picture on the right in any detail in terms of how it's structured. It is a largely written procedure. It's front-loaded, so you have to spend a lot of time getting your arguments ready before you start, and you're going to have lengthy written claim brief, basically setting out your not just a very short form. We say it's infringed by this product, but very much explaining the technology, the background, explaining the patent, and then explaining why it's infringed. The essence of it is the rules assume that there's likely to be a patentee bringing an infringement case, a defendant denying infringement but counterclaiming for invalidity, and the patentee responding to that invalidity claim with patent amendment application. And each of those, infringement, validity, and amendment, there are 4 pleadings, basically a claim, a defense, a reply, and a rejoinder. And that sets out the written documents that you would expect to have. Now, overall, it is much more in line with continental legal systems. So, yes, there is a role for experts. Parties are allowed experts. The court itself could appoint an expert. I'm not aware of that ever having happened in any of the cases that have been issued so far. And the party-appointed experts, the parties serve expert reports, that it is possible for the court to order cross-examination of the expert. Now, that has only happened with one division so far. And so when we look at the impact and how we litigate forum shopping, we're going to be looking very hard at which divisions are inclined and really that comes down to the individual judges to say, well, I think we should have some cross-examination, but it's going to be nothing like the cross-examination we're used to in common law systems where, very lengthy, it could be, half a day to a day or even more than a day of cross-examination of an expert. It's going to be much more, maybe an hour or two, some questions to sort of provide some testing of the evidence. And that is because we have these technical judges. When it comes to it's not that we're trying to persuade a jury and they've got to listen to an expert to try and understand, the basics of this technology and be taught about it. The basics of the technology is something which we were already going to have one, if not two, on the appeal stage, 2 technical judges who know it. And so they are not going to be swayed by the fact that a party has managed to find somebody who can support their case with an expert testimony. They're going to be able to, they will find it useful. The technical judges are not going to be absolute experts in every area of technology. So there is a role for educating the panel for experts, but it is far, far smaller than we're used to in, say, the United States or the United Kingdom. Now, in terms of language, I promised I would talk about that. And the English has already become the most common language for UPC proceedings. It's English and then German, and and after that, a very small number of cases in other languages. To summarize, if you're bringing it in a central division where revocation cases come, the language of proceedings is automatically the language of the patent, and the vast majority of European patents are published in English. English is the language that was used during the patent prosecution at the EPO. For infringement proceedings, where the local and regional divisions are most commonly used, every single division has said they will accept cases in English. And right up until day one, it wasn't clear whether the German divisions would or not. And so there were 15 cases filed on day one, and they were all filed in German just to make sure that they would be accepted. And on day one, the German division said, actually, we will accept English as well. Now, the German divisions are the busiest. And when you have German litigants using German divisions, it's natural for them to using German law firms. It's natural for them to use German. So we do still have a 40% or so of cases in German in the UPC, but it's more than half are now English, and this is steadily increasing. And again, we multinational judges. English is the language they prefer to work in.
Oh, Grant, we got a question about the application to amend. Is there any indication of whether the ability to amend the claims during proceeding will be easy or difficult?
Yes is the is the short answer, because we're already seeing the cases coming to trial and the applications to amend, and perhaps I should have said yes and no. It's a matter of the rules. There are some parts that are easy, which is it is most definitely the court is happy to entertain amendment applications, and indeed because the rules anticipate it. And so that is absolutely fine. The potential no is compared to, say, the EPO, where people might turn up at an EPO hearing with dozens and dozens of auxiliary requests, going through one by one and saying, well, if you don't like this claim set, how about this one? And then on to the next one, and then on to the next one. We're seeing, this is something people were working out as litigants. Will the divisions expect lots and lots and lots of claim sets like this following the EPO, or will they be much more limited? And the case law we have so far now is saying you've got to strike a balance, that it's got to be manageable. They're not going to let you turn up with 200 different amendments and say, right, we're going to actually try and cover every single one of these in a hearing. Bear in mind that they expect a final hearing on patent infringement and validity to be 1 or at most 2 days. They're not going to entertain days and days of discussion about endless claim amendments. However, that doesn't mean they won't allow quite a reasonable number of auxiliary requests, because the way that it slightly does seem to follow the EPA practice of saying, well, this is the claim set. And you imagine if you have lots of different features, just tweaking one and then the knock-on effect on dependent claims, if there's 2 or 3 main amendments you want to debate, the number of permutations, if you have to have a claim set that covers different permutations of each of those 3 amendments, you could immediately have 6 different auxiliary requests. And the indications are that they will tolerate that if what you're really saying to the division and the judging panel is, look, there are 3 basic amendments we need to consider, and these are just different permutations, then that's something they are likely to allow to go to trial. And what happens in the procedure is once the written pleadings have all been filed, there is what's known as an interim conference, And this is where the judge rapporteur of the three judges on the panel makes orders to prepare the case for trial. And this is where you would expect any argument over the number of amendment requests to be determined. So finally, I'm talking, the impact, and the main theme, the main message I want to give this, today, is about forum shopping. What we now have is an extra court on the European litigation landscape. It is not that you just have to say, okay, we can forget about national courts, and also that you can forget about, say, European opposition proceedings at the European Patent Office. You can't. All of these can now run in parallel, particularly because we have transitional provisions. And that means that you have this co-jurisdiction of national courts and the Unified Patent Court, though there is the complication of the opt-out for the patents, but it means that we have to think about everything. And so we have to think about it right now when we're prosecuting patents and deciding on patent prosecution strategy and applications. We have to be thinking, where might this patent be litigated? Do we want to make sure that it never comes before the Unified Patent Court? Well, if we wanted to do that, for example, the way to do it is to file not European patents, but national patents, because there is no possibility, if you file a German national patent, there is no possibility of that being litigated anywhere else than the German courts. If you file a European patent, you can file it and opt out at the moment. And the transitional provisions say, okay, as long as that opt-out's not withdrawn, it will never come before the UPC. So we have two options there for making sure the UPC never has jurisdiction. If, on the other hand, you want it to have jurisdiction, well, you can go for unitary patent protection, you can go for a European patent, but not opted out. The danger, though, is you can't, if it's not opted out in the transitional regime, you cannot stop someone bringing a revocation action in the national courts. It's co-jurisdiction. So the only way you could guarantee that your validity would only be determined in the UPC would be with a unitary patent. Now, if you have enough money, you would want to be prosecuting a whole family of patents and filing divisionals to your European patents, or closely related patents in the same family, all claiming priority, potentially from one central filing, one US filing. And then you could use all of these options to create a whole patent thicket of national patents and European patents and unitary patents, which would make it, a huge barrier to any competitor to entering your market. So that's in the perfect world. In the real world, nobody's got endless, infinite budget for patent prosecution. So we have to be thinking right from the beginning, what's going to be best for me and the protection that I'm seeking to obtain.
Oh, Graham, we got a question. How does the nationality of a company or patent owner affect the ability to get UP patents and participate in UP proceedings, if it does? Like, for example, is there something a UK company cannot do because UK is not part of the UPC agreement?
The short answer is no. Anyone can apply for European patents, and you have these options of obtaining unitary protection, and it doesn't relate to the nationality of the applicant. There is so far an entirely technical point about the nationality, and that is to do with the sources of law that the UPC looks to when deciding its cases. And the starting point is EU law. The second, it looks at the UPC agreement. It looks at the European Patent Convention. But if you keep cascading down the tree, eventually you come to the national law of the country of the applicant. And so it's just possible that some case will come up one day which involves national law. And if you're not if the applicant is not the national of a participating country, or is not is not a company domiciled in a UPC country, then the default is German law. So it's highly technical. It's just possible in some case that there could be some issue of national law that might have some determination on the outcome. But I have to say, off the top of my head, I can't think of anything, and it certainly hasn't come up so far in the court's operation. So if we now look at moving on from just deciding which patents to file, we need to look at the fact that there's routinely opposition proceedings in the European Patent Office. There's a 9-month opposition period where somebody who wants to object to the grant of a European patent can file their opposition. And then those proceedings can take years. And the point I just want to make today is that, again, we need to think of UPC in parallel with the opposition. Because the great thing about an opposition is it's relatively cheap. And if it's successful, the European patent is revoked in all countries in which it otherwise would have taken effect. And that compared to the cost of trying to revoke a patent in national court proceedings, that can be a huge cost saving. But we now have the UPC, and yes, a European patent can be granted in countries like the UK, and you won't be able to revoke it in the UK through the UPC. But if you think about European countries in which a patent might be granted, validated, you can now seek to revoke it in UPC proceedings. And the problematic issue might be if you launch an opposition without having thought first, might we want to bring a UPC revocation? Because if I were a patentee or advising a patentee of a European patent, and somebody starts opposition proceedings against it, I will immediately be saying to that patentee, well, if this opposition, doesn't succeed, or if it just takes too long, if my patent hasn't been opted out of the UPC, this opponent might well start UPC revocation proceedings. So perhaps it would be a good idea to file an opt-out right now, if I haven't already, to make sure that the opponent cannot bring UPC proceedings to revoke the patent. And if I then if I file that opt-out and I don't withdraw it, that will ensure that the opponent can never bring UPC proceedings for central revocation of the patent in all UPC states. So equally, if I'm advising the opponent, I need to say, well, if the patent hasn't been opted out, you have an opportunity here to file a UPC revocation action, and I cannot guarantee that that opportunity will still be there if we don't file it now. So it will, of course, be a higher cost, but the central arguments for revocation may be almost a cut and paste job. And it's, there will be, it's quite a relatively high initial court fee. You've got to pay 20,000 euros to start a revocation action. But, compare that with starting 6 revocation actions in national courts, you may well be thinking, I better start it now. So that's another bit of the parallel proceedings and a little bit of the patent strategy that we're going to have to take into account with EPO opposition proceedings. Then we come to other courts. And what we've seen is the UPC has not just been a nice, simple, cheap, effective court, favorable for small companies that can resolve the disputes, and you don't have to worry about any court proceedings in other countries. Inevitably, the fact that you can have national court proceedings in parallel with UPC proceedings, not on exactly the same parties, on exactly the same patents, that wouldn't work. But what if the parties aren't quite the same? If you have distributors, other people in the product chain, or even just different subsidiaries in the same group. The way the case law is going is they're all treated as different legal entities, and so you're able to run parallel proceedings. And one example, which I've had some involvement with, is a dispute between Edwards Life Sciences and Merrill Life to do with heart valves. And you will see there are proceedings in many, many different jurisdictions, national proceedings in several different countries, but also parallel proceedings within the UPC. So UPC proceedings in different divisions at the same time, dealing with different patents, different patent families, but also even parallel proceedings where we have different parties. So it gets very complicated very quickly. And I have to say that is not particularly friendly for SMEs, those small and medium enterprises who can't afford to litigate in multiple courts at the same time. And if we're advising them, we have to think very carefully about how we can try and make sure that they can't be dragged into lots and lots of different parallel proceedings. The other part to note is there's a significant jurisdiction, namely the UK, that is no longer part of the UPC. And so, whereas we are seeing, for all the fears I've just stoked about there being endless parallel proceedings, we are seeing a lot of cases where litigants are now just making the UPC their default court. And they're choosing to say, okay, we will litigate our dispute in the UPC, and we're not seeing necessarily parallel national proceedings with them, but they're not going to get a judgment in most cases which is going to apply to the UK. The court might entertain an infringement case in some circumstances, very unlikely that they're going to entertain a validity case. And would the UK courts anyway recognize an injunction, say, granted by the Mannheim local division in Germany? It's debatable. So in many cases, we're going to see litigants now saying, I've got a pan-European dispute. I need to also look at the UK. So I think we will see a lot of cases where we have UPC and UK parallel proceedings. Now we come to a few of the statistics, and I'm really just going to, in the last couple of
Graham,
minutes.
before we get into the statistics, we had a question about expected timelines. So are there any expected timelines for a revocation or an infringement action in the UPC courts? And how do they typically compare to national courts?
Thank you. That's a very good point. And if I come back to this slide on the procedure, if you get your magnifying glass out and you look at all those boxes and you tot up the months that are written in them, what we'll see is the procedure is designed to bring a case to trial within a year of issue. And the court is working incredibly hard to achieve that. And in most cases, they are doing it, which is quite phenomenal when we're dealing with infringement and validity and very often amendment. And it's partly why, for example, I think we're not seeing expert cross-examination more, because that inevitably builds in a bit of delay. We need a bit more time. If you cross-examine the experts, you then need to give the parties time to comment on the cross-examination. So in terms of 1 year to a trial on infringement and validity, that is fast. And it's up there. The UK was traditionally probably about the same to trial, and that was a selling point for the UK. Well, it no longer is unique in that front. Most other European national courts would have taken longer, and certainly when you looked at the appeal stage, the UK is less than a year. The UPC is looking at 1 year for the appeals, and we're about to see how well it can keep to that as we're getting into the second year of operation of this court. But overall, it is turning out to be relatively fast, similar perhaps to the UK, but of course covering a much bigger territory. So that's been very successful so far, if you want speedy determination. What I haven't seen is the extent to which it might be willing to accelerate proceedings. If you had something really urgent across Europe, that is something where I could certainly advocate for coming to the UK. The fast example I can think of is a case that went to full trial in 4 months from issue, and then went to appeal 2 months later. So if something is genuinely vitally urgent, then the Patents Court in London is particularly fast. And I'm not sure whether the UPC could do that. It can, of course, do preliminary relief, which might be its way of addressing something that urgent. So in terms of its success, and has it had the impact? Well, the first instance court has already received 700 cases. That is counting infringement and revocation counterclaims separately. So it is fewer, if you like, actions than that. But in terms of totting up all the revocation claims, all the infringement actions, and preliminary relief, it has got to 700 in just 18 months. I mean, this is already, I would say, the main forum for patent litigation in Europe. And so we simply cannot ignore it. On the contrary, we must embrace it. I think it's been phenomenally successful. That's because of the enormous amount of work that went into planning it and getting the rules. It's a testament to the quality of the judges who were taking part. Basically, most of the leading European judges in patent law are involved in this court. What still needs to come? Well, the case management system is dreadful. That is one thing that every litigant, and I've tried using it, it is so hard to navigate. And the court has accepted that. They're working on a new case management system with the European Patent Office. They hope to have that issued during the course of this year. Back to their report and the annual review. There was one comment from Florence Boutin, who's president of the Court of First Instance, that I think is really quite interesting. And that is that in terms of areas of development, she talks about the case management system. Then she also says another focus is the harmonization of caseloads across the divisions. Now, I think that's quite interesting because if we look at the numbers here, and I've got it in pictorial form here, we can see that if we look at the German local divisions, so far they seem to have about 60% of the work. And I think that is a concern amongst the participating countries because they want to see this as a multinational European court. And I don't think they really want. Germany will always be hugely influential because it has always been a very highly respected center for patent litigation. And therefore, we have true expertise amongst the law firms and the patent attorney firms for patent litigation. But I think we see there a desire, I think, from the judiciary to see a more even spread of the caseload. So we'll need to see how they hope to achieve it. For me, I think there are lots of excellent judges in other divisions. I'm surprised we haven't seen more in The Hague, more in the Nordic-Baltic division, for example. But I think over time we will, particularly as case law, as jurisprudence is established, and we can be confident how first instance divisions will behave regardless of where they're located. Language, just to come back to one of the original questions, here's the pie chart for how things stood at the end of January, 54% English. Now, I think that's probably a good point for me to wrap up. You will see that there's other statistics in the case, the number of caseloads, the type of the cases. I think it's a useful resource for anyone interested to be able to refer to in the handout. And of course, I'd be delighted, if anybody either now or afterwards wishes to ask questions, I'm more than happy to respond. And or come direct, or please funnel them through Adeel and SLW. That would be a great way.
Thank you, Graham. That was very informative. And I think we have reached the end of our time. And thank you, audience, for joining us. And please be on the lookout for future webinars.